Good afternoon. We're going to get started. My name is Suzanne Kahn. I'm the Senior Vice President of the think tank at the Roosevelt Institute, and it's my pleasure to welcome you to today's discussion, The American Economy and Democracy After Dobbs. 3 years ago, the Supreme Court decision in Dobbs versus Jackson Women's Health Organization overturned nearly 50 years of precedent protecting the constitutional right to abortion. Since then, a cascade of conflicting state-level laws has reshaped access to reproductive health care for millions of women across the country. But the impact of Dobbs reaches far beyond the healthcare system. The ruling imposed new financial burdens on women, limiting their ability to make decisions about their lives and future. These burdens are forcing new patterns of economic participation and deepening inequality. At the same time, the post-Dobbs legal landscape is increasingly fractured. States are not only passing conflicting laws, but also testing the limits of their power across state lines, opening new theaters of conflict between states and creating more uncertainty for women and their healthcare providers. We're joined by three experts who can help us unpack what a post-Dobbs world means for who has power in our economy and democracy. Our moderator this afternoon is Hannah Grosh-Begley, Managing Director of the think tank here at the Roosevelt Institute, and I will turn it over to her.
Thank you so much, Suzanne. And thank you everyone for joining us today. I'd like to welcome our two panelists. First will be joining us is Rachel Rebouche, who is a fellow here at the Roosevelt Institute and also the Dean and James E. Beasley Professor of Law at Temple University. And Kate Bond, Chief Economist and Senior Vice President of Research at the Institute for Women's Policy Research. So Kate and Rachel, thank you both so much for joining us today. As Suzanne pointed out, we have in the last 3 years experienced quite a shift, and this is quite a topic that we're going to dive into today. We went from a system under Roe v. Wade, which was a nationwide law and system that protected access to abortion for all Americans. But 3 years ago, the U.S. Supreme Court case Dobbs v. Jackson Women's Health Organization shifted us instead to a state-based system. And in theory, this was pitched in part as a way to kind of put us back in neutral when it came to reproductive rights, allowing each state to decide for themselves what abortion in their borders should look like. But as both of you have argued, the reality has been anything but neutral. And in fact, in the 3 years since the court case, we've seen profound impacts and changes on personal rights, democratic freedom and accountability, and economic opportunity. We've seen that reproductive rights is so much more than just healthcare, and that it in fact is a market and a space that profoundly shapes our economy and our democracy. So I'd like to kick things off by just actually asking Kate to give us a little bit more of an overview of what has changed since Dobbs went into effect and how new restrictions on abortion access have changed women's economic mobility and power.
Sure. I'm really glad to be here to talk about this, as depressing as the topic might be. And first, I want to start by taking a very quick step back to just frame why this is an economic issue, to help us understand the actual level of the impacts. And so the way I typically think about both abortion access and reproductive rights broadly as an economic issue is that it has direct and indirect costs on workers. And so we know from plenty of research that if you have an unplanned pregnancy come to term, you faced direct costs in your life. You have a child that you need to care for who is very resource intensive. And so research has found that women who would have preferred an abortion and could not get an abortion because of restrictions, pre-Dobbs restrictions in their states, were much more likely to have filed for bankruptcy, to have been evicted from their homes, and to face other financial hardships just from having had an unplanned pregnancy brought to term that they would have preferred not to. So there's a variety of direct costs. Likewise, if you are seeking abortion care and there's longer travel distances, there's more clinic congestion, there are higher costs of accessing that care in many cases. And then the indirect costs, I think, are an important and especially relevant piece to think about in this, that the uncertainty that women across the entire country currently face because of a lack of access to abortion in certain states harms all women, because if you are not sure if you can control your reproductive future, you are going to make different investments in your career and your economic stability than you would otherwise. And we know this from previous research, pre-Roe, post-Roe, for example, that when women had access to abortion post-Roe, they started going to graduate school at much higher levels than they did. They're much more likely to become doctors and lawyers. Their ability to advance in their careers had an impact on reducing the gender wage gap. And so it's not just those direct costs of the cost of accessing care or the cost of having an unplanned pregnancy, but those indirect costs too of not being able to make decisions because you face so much uncertainty in the economy. That was not quite a quick step back, but I wanted to sort of frame it in like, why does it matter? And so what have we seen happen since Dobbs? We saw sort of an immediate increase in the severity of restrictions that women face across states. So total bans is something that did not quite exist before. There was sort of near total bans in some cases. And Rachel can also talk about the legal case, like the legality of what these bans actually look like more than I can. But we had a lot of extreme restrictions go into place right away. And so IWPR's most recent analysis, where we look at severe restrictions, 16 states that we say have the most severe level of restrictions from the last time we did the data, based on how Guttmacher categorizes severity of restrictions, those 16 severely restrictive states cost the national economy $64 billion a year. And the mechanism that this happens through is that reducing women's labor force participation because of a higher incidence of unplanned pregnancies leads to lower income for women in those states. And so those are on the magnitude of, if we eliminated all the current barriers, we would increase annual earnings of reproductive age women by 8.5% and labor force participation by 1.2%. And so when we sum the cost of that across whole states, it's 64 billion for the severe restriction states. And then across the economy too, even states that have that have a legal right may not have good access, or they're sort of in between restrictions. And so the total cost across the economy is $130 billion per year, because the current landscape of policies that restrict access to abortion care.
Thank you so much for that, Kate. A great overview of both what has changed in individuals' lives and then also how that has severe ramifications across an entire state economy and therefore our country, and really resulting in billions of dollars lost because of lower workforce participation and other limits. Rachel, I'd like you to come in here. So as we've sort of hinted at, this new system has sort of put the question back to the states and allowed states to kind of quote unquote decide for themselves. But we've also seen that that has increased sort of state versus state interactions and states trying to figure out what they can control within their borders and also outside of their borders. So could you walk us through what shield laws are and what roles they have begun playing in shaping this state versus state dynamic in these past 3 years?
Sure, and thanks for having me join today. It's an honor. So, as Hannah set out in the background, since the overturning of Roe v. Wade in 2022, the emerging legal landscape is increasingly punctuated by interstate conflict. It's not that states agreed on abortion policies before Roe was overturned, but the differences are a bit more stark, as Kate said, with 12 states that ban abortion from their earliest moments of conception, for, in addition, banning abortion after 6 weeks. But really, the interstate conflict that we're seeing in this post-Dobbs landscape is one in which states are seeking to apply their policies on abortion across state lines, or at least have some effects of their legal regimes felt in other states. So just to begin, consider the so-called abortion trafficking laws. These laws make it unlawful for any person to knowingly transport any individual for the purpose of providing or obtaining an elective abortion, regardless of where the elective abortion will occur. These are laws passed by states like Tennessee, Idaho, counties in Texas, more on the slate for consideration by additional states. The aspect of this law in Idaho that touched on speech was enjoined, but really the moving of minors was allowed to go into force, and we can talk more about that in Q&A. So that's all to say that states are not just passing abortion bans after Dobbs, but they are also enacting laws that seek to protect their right to ban abortion in their states and potentially for people who leave the states. It's an anticipation of this interstate conflict that 22 states have passed shield laws or executive orders, 22 states and DC. So what are shield laws? Shield laws are a new form of legislation that seeks to protect people who provide or receive abortion care within the shielding state. So as I said, 22 states with some form of protection, 18 with a statute. And though the statutes differ from state to state, they have some commonalities. So for instance, shield laws seek to protect in-state providers' licenses and malpractice insurance rates. So if a non-shield state tries to impose criminal or civil liability on a healthcare professional providing an abortion to someone from another state, that prosecution or lawsuit could be reported to the provider's licensing board. If you're named too many times, if you're subject to a disciplinary investigation, even if you prevail as a provider, that could result in licensure suspension, higher malpractice insurance costs, reputational damages. So shield laws first prohibit state medical boards and in-state malpractice insurance companies from taking any adverse action against providers who face out-of-state legal consequences for assisting abortion patients. The second aspect of shield laws worth summarizing briefly prohibits state officials from complying with requests related to interstate investigations of legally protected reproductive health care, both civil and criminal. So nestled in this point is every statute, for instance, defines legally protected reproductive health care, which includes abortion in most states, gender-affirming care, contraceptive use. And what shield states have done is attempt to exempt abortion providers from the requirements of interstate discovery, from witness subpoena laws. And these are actions that states otherwise encourage each other to cooperate with local law enforcement agencies. But shield provisions attempt to curb in-state investigations, applying only to that legally protected reproductive health care in the provider's state. Third, shield policies exempt providers from a state's extradition requirements, so long as the provider isn't fleeing from justice. This covers the provider who never stepped foot in another state. Many states have previously enacted extradition laws that permit or obligate the state to extradite accused criminals, even if they haven't been to the other state. And shield laws create an exception to those requirements. And I know I'm getting a little bit in the weeds, but given how many states have enacted these provisions, I think it's worth just understanding what they have in common. It makes the challenge to shield laws makes a lot more sense. Fourth, some shields laws in states and DC create a cause of action against anyone who interferes with the provision of legally protected reproductive health care. So these laws are written in a way that attempt to recognize out-of-state judgments, but subject the person that's seeking to enforce a punishment against a shield provider to a new state tort claim. And finally, and I think this is where a lot of our conversation, this is where a lot of our conversation might focus. 8 of the shield states, so 8 of the 18 statutes passed by various states, seek to protect providers who are not only providing care to those traveling to their state, but also providers mailing medication abortion pills out of state, even to states that ban abortion. So these provisions deviate from typical telehealth policies in some ways. Usually the standard of care is defined as the location of care where the patient is. By changing the definition of legally protected reproductive health care to be protection regardless of patient location, which is loosely the formulation these 8 states use, it shifts the coverage of these 8 states shield laws. And I think it's really on the back of these laws, these 8 states, Massachusetts, New York, California, Colorado, Washington, Vermont, Maine, and Rhode Island, that we've seen medication abortion, the 2-drug regimen of mifepristone and misoprostol taken 24 to 48 hours apart from each other within 10 to 12 weeks of pregnancy. We've seen mailed medication abortion from shield states across the country. And I think Kate's going to speak to some of what we're seeing in terms of the difference of abortion rates post-Dobbs. But that's generally what shield states laws do. And they are in response to what it was at first a hypothetical and now a practical concern about how various states' abortion policies could be enforced, or at least attempted to be, how states might attempt to enforce those policies across state lines.
Thank you for that, Rachel. And yeah, a very complicated situation. And I really appreciate you breaking it down because, we really have gone from a situation in which, the different states had different levels of access when it came to particular kinds of laws on the books, particular kinds of clinics that were open and available there. But now we really are seeing this very complicated legal maze that's cropping up. And not even all shield states are the same. As you pointed out, some shield states have certain kinds of provisions that others don't. And so it really is a whole new world for both patients and providers when it comes to understanding their legal rights, understanding what other states might care about in terms of their practices and might want to have a say in. So I actually want to ask you to break down for us, just as one example, there was a really recent case against a California provider that has been in the news lately. And this might help just, put this in some concrete terms for people about what the risks are and what the legal challenges that people are facing at the moment look like.
So it really is it's ground that's still being tested out. So the case that Hannah's referring to is a case brought by a Texas individual, Texas resident, suing a California provider. California is one of the shield states that I mentioned that has the regardless of patient location language in defining legally protected reproductive health care. For wrongful death, alleging that his partner took pills shipped to Texas from California, which caused the death of the unborn, and Texas defines wrongful death actions, which is a tort action, as covering the unborn. And so this is a cause of action that many have thought would come out of Texas or states that define wrongful death, this tort action, and include the death of the unborn. And it is the first case that is in federal court because there's diversity jurisdiction. 2 individuals in separate states alleging damages beyond $75,000. And it's on the back of 2 other notable challenges. I just pause here for a moment to note that the first shield law was passed by Connecticut in the spring of 2022, before Dobbs. When Dobbs had been leaked, people expected the outcome to be one in which states would be given the right to legislate or ban, as they saw fit, abortion. And it's been 3 years, and there's been 3 instances of challenge to the provision of medication abortion from a shield state. And so that's notable. There have not been a wave of attacks on providers in shield states, but the first 2 were taken by the states of Texas and Louisiana. So preceding this current wrongful death action, which also we can talk about some of the other aspects of that lawsuit that might be interesting to the people listening. The Comstock Act being invoked at one example. But those earlier, the earlier challenges, which were earlier this year, a civil lawsuit brought by Texas by Attorney General Ken Paxton against a New York provider, alleging that the New York provider mailed medication abortion into the state of Texas and violated Texas's abortion ban, as well as Texas licensure laws. Won the case in Texas court, in a state court, and then is now in the process of asking New York courts to enforce that judgment, which New York courts have not done, in large part because of the shield statute that New York passed. And Louisiana, prosecuting the same physician in New York for allegedly mailing pills into the state of Louisiana, and calling for the extradition of this doctor to Louisiana to stand trial for these charges. New York, as I just mentioned, looks to its extradition clause, its non-extradition clause in its shield statute, and says, no. I mean, the governor of New York has been explicit in saying, I'm not going to extradite that doctor today, tomorrow, or ever. And so the conflict between states like New York and California and Texas and Louisiana, it's here. It's happening. But where it goes, I think that's a question that a lot of us are following as these different issues of federalism, of constitutionality, of interstate relationships, as those are getting, as those play out in courts. I'll just quickly say at the same time, just last week, you see attorneys general, a cohort of Baptist ministers, various private persons writing to Congress and the Trump administration, asking for them to weigh in on these controversies, in part in the aftermath of the publicity of the California case that we just discussed.
Yeah, so a really interesting situation where you've touched on a lot of different things there. And I want to remind our audience that at any point, if you have questions, you can put them in the Q&A function at the bottom of the Zoom screen. And then at the sort of back half of this conversation, I'll take those audience questions and pose them to our panelists. So please feel free at any point to add those questions in, because we're touching on a lot here. This is, as we said, it's been a crazy 3 years. A lot has happened, a lot more to come. But part of what you're touching on, in addition to this interesting tension between a sort of states' rights-based system that then people are like asking for federal fixes on, which I think is a really interesting tension. You're also talking a lot about how the nature of abortion itself has changed in many ways, and some of these laws and some of these systems might have been simpler, or might have been a little clearer in, say, the years before medication abortion was so prevalent and so popular. So, Kate, I want to bring you back into the conversation, that, to help us think about what about the pre-Dobbs landscape is really important for us to understand about what's happened in these 3 years post-Dobbs, because it isn't really like everything just reset in June 3 years ago, that things had been changing before that have contributed to this mess we're seeing today.
Yeah, and so to sort of pick up on where Rachel left off, one of the sort of surprising findings post-Dobbs has been that rates of abortion have gone up post-Dobbs and compared to pre-Dobbs, and a lot of that is explained by the expansion of medication abortion that was already happening pre-Dobbs. And so there was an expansion and more legal pathways before Dobbs, but as abortion in person in clinics became less accessible, more people across the country have been able to access or tried to access medication abortion. And so that is one of the reasons that there has been an increase in the rate of abortion post-Dobbs. And then another piece that I think is also important to think through here is that a medication abortion is a great option, particularly in the current landscape. But in a world where everybody had complete reproductive rights nationally, that might not be the decision individuals made between themselves and their doctors. There are, lots of other ways to manage abortion and miscarriage, which are medically identical. And going to clinics is the other way that people would have a surgical abortion or otherwise. And what we're also seeing, pre-Dobbs started to hint at this, and now we're seeing an extreme version of this is clinic congestion in those places that are border states that do have access to surgical abortion and other types of services. And so there's research, for example, the pre-Dobbs that found that Pennsylvania, as a state, would had some extreme clinic congestion based on their location compared to states that were less accessible. And now we have entire regions of the country where in-person clinic surgical abortions are not accessible. And that would both increase clinic congestion for those who are receiving a surgical abortion, and then also pushes people towards medication abortion when otherwise that may not be the best option for where they are, what stage of pregnancy they're in.
That's very helpful. And I could you also touch on it? You've talked in the past a little bit about how the sort of the economic impacts of having this patchwork that again we saw a little bit before Dobbs, but I think has only increased since Dobbs, of things like where people even want to work.
Yeah. And so this is another piece too that we have done research here at IWPR on, is like the impact on workers and their geographic mobility across the country. There were, of course, really extreme bans, and places that tend to have less access to abortion care are also ones that have worse access to maternal health and prenatal care. And workers who want to start families don't want to start families in those places. And so we have done, survey research of workers, finding that those who are of reproductive age and want to start a family do not want to go to states that have bans. Likewise, employers are thinking through, how can we recruit workers if we are based in a banned state? Or how can we set up workplace policies that will help workers if they are in banned states? And so employers are also having to think about this, because this really matters for their recruiting. But the one piece I sort of want to mention here as well is that there's just two completely different reproductive regimes for workers who are professional class and other workers in terms of what types of decisions they get to make about their geographic mobility vis-a-vis the reproductive rights landscape in their states. The idea to relocate to another state for a job tends to be more of a occurrence that it's going to be a professional class worker with an advanced degree following a career trajectory. And there's a lot of other workers. Most workers are not in that position. And both of these ultimately, serve the interests of capital. And so I'm thinking of a great paper that came out by the economists Annie McGrew and Jana van der Meulen Rogers on what does it look like when you have one group of workers in a very precarious situation who have to stay in those states with bans, who are more likely to have to bring unplanned pregnancies to term and face these economic costs that keep them in those precarious low-wage jobs. And then another class of workers who are employers can offer these incentives or provide better access to care. And it is still often in service of capital, so that they delay child rearing, so that they stay at the company for longer without taking as much leave. And so both of these, like this, we've sort of set up this regime of like two ways that employers can benefit from this patchwork of access to reproductive rights across the state.
Thank you. Yeah, I think it's been really interesting. I mean, I think even it was Citigroup that like almost immediately after the Dobbs decision came down announced that they were going to be offering workers benefits for travel for abortion, that was going to be part of their like employee benefits package, which is, I think highlights exactly what you're saying, that there are very there's like many different economies and many different ways in which people can actually access economic power under this system. But it's so
Yeah. And to like just expand on it, it's sort of like employers now have to like think about this tension of using like recruiting tools that it's hard to recruit to banned states, or you offer these packages. But then it's also, I mean, just the premise of an employer offering to cover the costs of abortion care is, is that just PR for companies, or is that actually a service that people are willing to take advantage of?
Yeah, it's a really good point. Rachel, I'd like to bring you back in on this question of like what we need to understand about what happened pre-Dobbs to understand this post-Dobb landscape. I mean, you mentioned before this the importance of this transition to medication and the transition to more in-home care than clinic-based care. But what are the other legal implications you've seen?
So, just as Kate said, the increased use of medication abortion is a pre-Dobbs development. There were years of studies of how abortion pills could be taken on one's own without provider oversight and outside of a healthcare facility. And that really was given legal footing during the COVID-19 pandemic, when in 2020 a federal court said, here's an idea of how to reduce patient-provider contact. Why don't we allow people to take medication abortion on their own with a certain protocol that's been borne out with years of research? And so what that court did 2 years before Dobbs is suspend an FDA rule, a restriction on mifepristone, the first drug in a medication abortion, that required people to pick up the pills at a healthcare facility. Well, actually, one pill, it's mifepristone, followed by pills, misoprostol, but it's mifepristone that is approved for abortion in the United States by the FDA. And so in suspending that in-person pickup rule, virtual clinics flourished. You could take, for example, Abortion on Demand, which is the first large-scale US-based virtual clinic, which has counseling online, which provides informed consent and other information that someone might need in taking medication abortion online, does follow-up online, and mails medication abortion to that person at their home. It's a organization that operates in 25 states where telehealth for abortion is legal, where abortion is legal. It takes between 24 to 48 hours for the whole process, and costs about $300 with a sliding scale for income. So it's groups like this type of virtual clinic that really, I think, on the back of lifting this restriction, ushered in a new way of thinking about how abortion could take place, one in which there is not contact with a healthcare facility or a provider in person. And post-Dobbs, we've seen mailed medication abortion really take off, for lack of a better phrase, really increase. So I think Kate alluded to this, the most recent studies of abortion nationally find that the average number of abortions in this country has increased since Dobbs. So again, since Roe v. Wade was overturned, there are more abortions happening in the United States. And that is in large part because of medication abortion and mailed medication abortion. So the shield states that I mentioned, those 8 states that have legally protected reproductive health care defined regardless of patient location, this same study estimates that providers from those states mail over 12,000 packets per month of medication abortion, which is really different than how abortion care happened before Dobbs and before 2020. There are real caveats that I think we could get into about who can avail of telehealth, who can avail of medication abortion, but it's certainly changed the landscape by which people seek and receive abortion services. And I think it's on the back of those changes that we've seen efforts to impede mailed medication abortion from groups who do not support abortion rights, or from states that want to shut down mailed medication abortion as it currently exists.
Thank you for that. And yeah, I do want to touch on some of those caveats that you mentioned, because while it is absolutely, I think, incredibly important to note that the total number of abortions has actually gone up. Another great economist on these issues, Caitlin Myers, who did some work with Roosevelt, has also shown that only like 20 clinics total across America have actually shut down. So like there really has been, I think, less of that sort of sheer numbers change that people were thinking might happen. But I think it's also really important that we talk about how this hasn't happened equally across all groups. And so Rachel, just sticking with you for a little bit, like let's dig into that a little bit. What does it look like for more marginalized groups? How has this changed for them?
So Caitlin Meyer's work is phenomenal in this space. Abigail Aiken, Carrie White, researchers who show that though the number of medication abortions has gone up and they now account for the majority of abortions in the United States, medication abortion is not going to be prescribed for someone who's past the first trimester of pregnancy. Now, we know that most terminations happen in the first trimester, but nevertheless, if you are later in pregnancy, you are not a candidate for medication abortion. You are not a candidate for medication abortion if you have certain health complications, if you have a complicated pregnancy, if you are taking medications that are contraindicated for medication abortion, you're managing other conditions and the like, and that's not an insignificant segment of our population. And we know that people who have health complications in pregnancy or are taking medications that can be contradicted by medication abortion are often people who are not wealthy and not white. And so those health disparities that characterize our healthcare system in the United States, those carry forward and through the delivery of medication abortion. Not to mention, for mailed medication abortion, you need an internet connection. You often need a smartphone. You need digital literacy. So there are populations of people who are not being carried forward in this wave of mailed medication abortion, who are still and have been marginalized in seeking abortion care and frankly healthcare generally across in the United States.
Yeah, absolutely. And Kate, let's pass this to you. And what are the broader economic implications of this sort of disparate access and disparate impact that this new system has had?
Yeah, I mean, because of the demographic representation across the states, certain populations are more impacted just by virtue that they have higher representation in banned states. And so in particular, Black women are much more likely to live in the southeast of the country. And so Black women structurally are less likely to have access in their states to abortion care. And we looked at this in our recent cost reproductive rights restrictions analysis. And I said early in the webinar that if we eliminated all current barriers, women's income across the country would go up by 8.5%. For Black women, it goes up by 9.6% because Black women are so much more significantly impacted by having a higher representation in banned states. But more broadly, like economic precarity begets economic precarity. People just sort of are stuck in a impossible position if they are low income, marginalized, more likely to face discrimination in the workforce and in medical systems. The same types of racist and sexist discrimination exist in both spheres. And so what we're going to see is they have less liquidity to travel if they need to travel for abortion. Those economic shocks of having an unplanned pregnancy brought to term are harder for workers who have less wealth to fall back on. And then, these are groups that are already going to be facing the oncoming impact of the new bill that was just passed that reduces things like access to healthcare, access to anti-poverty benefits. And then, the other thing I'll say too is that we already have a maternal mortality crisis in this country. Abortion care is a key piece of prenatal care. We know that Black women in particular are impacted by a maternal mortality crisis, and now they have lack of access to healthcare services. They're more likely to have access to healthcare services that are going to exacerbate that existing crisis. And the loss of Black women through maternal mortality is like a severe human loss. And I don't want to diminish the human loss, but I also want to point out that that's an economic cost. Black women are more likely to be primary breadwinners within their families, more likely to be single mothers. They're more likely to have a critical pieces, caregivers within entire family networks, within entire communities. So the loss of Black women through this maternal mortality crisis is impacting entire communities economically, as well as, of course, like emotionally, the human toll there, but it is also an economic toll to exacerbate the Black maternal health crisis.
Thank you for that. I want to start bringing in some of the questions that we're getting from the audience. Rachel, we'll start with you. There's a question about, you in your discussion of the state conflicts that have come up post-Dobbs. There's curiosity if there's an equivalent issue, maybe outside of abortion, from the legal world that we could learn from, where this kind of state conflict has come up in the past, and that could perhaps give us a model for what we're going to see moving forward.
Yeah, thank you. I mean, I think there are analogies. So one analogy, for instance, that has been discussed, though it's an imperfect analogy, is the interstate differences for marriage equality, as states permitted couples of the same sex to marry and others prohibited marriage, as the federal government weighed in with its federal DOMA, as states passed their own versions. There was, I think, a legal landscape where the status of marriage depended on where you lived. And it's not a status that necessarily carried with you because of DOMAs. And so, I think that there's something to think about in how states negotiated those, thought about those differences, particularly as a status like marriage can crosses state lines as people cross state lines. And then I think there's been analogies drawn to the decriminalization of cannabis, and the decision of states to not enforce certain cannabis drug laws. In fact, this case didn't go anywhere, but Oklahoma sued Colorado when it decided not to prosecute cannabis-related offenses, and the market that grew up in that state, and this is not my area of expertise, but the market that then started to exist, Oklahoma sued Colorado to say, your law is allowing cannabis to come into our state because you know what else travels across state lines? People with cannabis in their mind. So, and that case didn't go anywhere for reasons that we can discuss. So, I do think there are analogies to make. I think that the question's a really great one because I think it's a mistake to suggest that we are in totally unfamiliar ground for interstate conflict. It's not true as a general matter, and it's not true for abortion. It's not true for abortion policy, which has diverged pretty dramatically before Dobbs from state to state. It's increasingly, I think, different as states pass laws to protect or pass laws to prohibit, but those fissures have existed for quite a long time. So thanks for the question.
Yeah, absolutely. Thank you. So Kate, this next question is for you. With so much government data on healthcare and reproductive healthcare specifically getting harder to access, in some cases potentially disappearing, how can folks make sure that they're getting accurate and useful info? What can be done long term to better make sure that we're collecting and analyzing accurate data? And then sort of a follow-up, what kind of data do you wish we had that we don't have right now?
That is a really, really good question. And like economists could talk about data access forever. There's a broader discussion right now about attacks on federal data and federal surveys that is happening and what the impact of that is going to be. And so, as you alluded to, the Center for Disease Control got rid of their the PRAMS database, which measures pregnancy, medical issues for people, and that we no longer have access to that data. Some private organizations downloaded what they could prior to it being offline in the government websites, but like we are losing access to really critical data that the government should be collecting. And I want to, point out that like I think government data is still the gold standard of what we should be using in research, because the government has a vested interest in, or should have a vested interest in having nationally representative data in the way that private data sources will not be able to do as well and may not be their primary objective anyway in that data collection. Putting that aside, we need national data. We're currently facing an attack on national data, but there are private data sources. There are ways to get at this. And so, you alluded to Caitlin Meyer's research. She has done really diligent relationship building in particular to make sure she is able to get data, particularly in this sensitive moment where clinics and providers can be criminalized. And so I think relationship building to get access to data is a really key piece, particularly in sensitive issues. There are other ways individuals can collect data by running their own surveys and doing the difficult work of trying to make it representative. And so researchers use a lot of tools like Qualtrics or by, using a firm like Morning Consult is one that IWPR has used in the past to be able to create their own data. And so those are sort of where people are going, is trying to collect their own data. But I think there's like a bigger question around data advocacy. The federal government is the most natural organization or party to collect this data in a systematic way that is nationally representative in the interests of people in the nation. And so we really need to advocate across the board to have that data. Oh, that was also a question of what data I wish there was. Here's the tricky piece. I think it's like, as an economist who has worked outside academia, it is harder for me to get access to certain types of data because in academia, sometimes you get better access to data because you're seen as sort of doing research just for the expansion of information and knowledge versus for a particular like policy effort. And so there is some good data that people can use on actual like medical billing codes to see how, what procedures actually take place. That data is very hard to get access to. I would love if that data was more accessible in an anonymized way that keeps people safe. And so I feel like that would probably be my like dream data, as long as it also has demographic information, because that's a key piece of this. But some of the data out there is just hard to get to paste depending on your location and also resources, because again, running those surveys yourself that I mentioned are prohibitively costly.
Yeah, absolutely. That makes sense. We've got a few questions in the chat that are related to a question I also wanted to ask you both, which is sort of like, what can we do about all of this? What can we think about solutions and proactive approaches? And particularly at the Roosevelt Institute, I think we're most interested in sort of thinking ambitiously about policy and what policy thinking in a space could look like, but also want to open it up if there are other avenues that you both think people on this call should know about. So maybe Rachel, we could start with you. What should those of us just in civil society or policymakers do to respond to this situation that we're seeing?
So I guess I would start with there's a great comment in the Q&A about the reproductive justice organizations that are facilitating medication abortion access on the ground. And I couldn't agree with the author of the question more, that they're really fascinating examples of other countries that have banned abortion for much longer, where there have been sometimes fragile networks, quiet networks, but nonetheless networks, on a scale of robustness that facilitate abortion care, procedural and medication in the shadow of illegality. And one of my areas of study happens to be comparative abortion law for this reason, because I think both as a matter of interpreting law, so the shadow of legality being both a ban, but then exceptions in a ban, and how those exceptions for abortion, for life, for health should be interpreted and applied by courts, but then in the true sense of being in the shadow of law, networks that facilitate abortion care as a source of civil disobedience, as a source of access to resources as a matter of justice, or as a type of care that people do not think of as abortion. So one of the things that's happening in this country, that's happened the world over, is thinking of reproductive health care as a more as a category that includes all kinds of ways in which people gain access to control over their reproductive lives. So in countries like Bangladesh and others, it's called menstrual regulation. And what that means is when you are late for your period, you go to someone like a community healer and you say, I'm late. Can you help me start my period? And they help you start your period. And it is not called an abortion because no one's ever tested you to see if you are pregnant. You were just late in your menstrual cycle. That exists in the United States in terms of missed period pills, in terms of advanced provision. There are lots of ways, both inside, outside, and in between categories of legality to think about reproductive health care. So I think that's one way to think about this in a way that's not as tethered to court decisions or to the text of legislative enactments. The next thing I would say is in terms of legislative enactments and in terms of court decisions, there's a lot to be said for some of the ways in which, I'll just take the examples of shield laws, that states that are so inclined are passing amendments to their shield laws to protect providers among states. So if you're a New York provider who's being targeted by, let's say, the state of Texas, you can travel to other shield states without fear of extradition or a lawsuit or other adverse actions. States like California that have passed laws that remove providers' names from prescriptions and just have the practice. So it's compliant with the FDCA, but isn't as targeting to the individual who is prescribing under their state's law. And doing so under their legal license, prescribing medication abortion. And then the next thing I'd say is that there's a lot of movement afoot for medical boards and other entities, national professional organizations, to help to train, to educate providers across states, in banned states and not banned states, about abortion care, particularly emergency care. And what new laws or new policies mean for the provision of that care. Those are just some examples. I could add changing prescription drug monitoring programs, the way that data is shared, but there's a lot to talk about.
Absolutely, thank you. Kate, I'll turn the question of what we should be thinking about doing and proactively to you. What does ambitious thinking in this space look like from your view?
I mean, I'm going to think of the research needs that I think are sort of critical to making the case, research that backs up both legal battles as well as just general information and people's understanding of the importance of abortion. I'll start with like the negative one, which is I think we need to start thinking realistically about modeling what a national abortion ban would look like. And that's very depressing, but economists have not really thought about that yet. They haven't thought about how we would measure the cost of something that has never happened. Our tools are very limited. Sometimes economists are not good at that kind of in general, but like, so maybe we're working with people across social science fields to figure out what would the cost of a national abortion ban be. And then on the more positive side, I think this sort of gets at a little bit of what Rachel talked about sort of like thinking more broadly about reproductive rights means, and bring the reproductive justice framework into how we research this. Because if we really want to be talking about research that would demonstrate the economic value, the personal value of women being able to have complete control over their reproductive decision making, that not only means a legal right to an abortion and financial access to an abortion, that also means access to the resources you would need to be able to parent with dignity. We need to think about sort of the broad pillars of reproductive justice. They're not just the ability to get an abortion, it's also the ability to parent with dignity. And so what would policies look like? What would the value of policies be that gives women the space to make the decisions they want to make about their family. And so, it's not just, so again, abortion, but also, do people have access to paid sick days? And I saw that there's a question in the chat about the Pregnant Workers Fairness Act about elective abortions. And so there's a question of like, do people have access to paid sick days, generally speaking, both for themselves to get abortion care, but also to take care of children? Do they have access to paid family leave to take care of children? Do you have access to flexible scheduling? Do you have access to housing, to food? All these things that when any individual is thinking about what would it mean to start a family if they want to start a family, it's not just, can I get an abortion if needed? It's also, I might want a family someday, but I don't have the financial security to make that decision right now. You need those other types of policies. And that's what I think real reproductive justice would be. And I would love to see research that is that ambitious and that holistic in how we think about this.
Yeah, absolutely. Rachel, did you want to comment on the national ban that Kate mentioned?
Yeah, I think it's such a good point. I think it relates to the maybe one of the final questions about the cost benefit analysis of what it looks like. And I think you mentioned this, Kate, to have not just decreased abortion in some places, but what a ban might do. And, I think we should be thinking about a legislative ban and be cognizant that, the de facto ban of enforcing the federal Comstock Act is real. So that is a centerpiece of the lawsuit that Hannah mentioned against the California provider by the Texas individual. And it's essentially bringing back to life an act passed in 1873 that hasn't been enforced in about 100 years. It's a vice law. And part of what it does is declare non-mailable matter, no mailing of anything, and that's the word, anything, that relates to an abortion. And Project 2025 and other groups have called upon the executive to to enforce the Comstock Act as a national abortion ban. And those efforts are ongoing. They do a lot. That the idea that it could be used as a ban is very real to what Kate just mapped out, because almost anything that travels through almost anything in an abortion procedural or medicine travels through the mail at some point. And so, I think trying to think about the response as these efforts get pushed forward, and as some of them have legs and some of them don't, it really makes a big difference. And I think that for me, thinking about that response is one of not just cost and benefit, but some of your allies, potentially unlikely allies, connecting the dots of all the various ways that something like a ban nationwide, or the bans that we have in a third of the country, how they affect physician education, OBGYNs who have to travel to get basic mandatory training that they have to receive in order to graduate from their residency programs. What does that look like? What we're seeing in emergency care, what we're seeing for our housing, our employment, our mobility. So, I think keeping that top of mind, that how these have ripple effects, how these policies and these movements toward total prohibition, what they will mean for so many different areas of life.
Yeah, thank you so much for that. And the Q&A is hopping, and I'm afraid we're almost at time, and so we won't be able to get to all of the questions that have been asked there. But maybe we could just close out with Kate, you first, and then Rachel, just telling us how people can find your work, how they can follow up on these issues if they have additional questions, where they should go to look. So Kate, I'll start with you.
IWPR.org is a great place to look and see our resources and the research we've done. You'll see both our cost of reproductive rights restrictions releases, as well as some recent work we've done on Black maternal health. So I really encourage people to go to IWPR.org and look at the reproductive justice and health equity section of the website. And if there are other questions about this, or people are doing research on this and they want to share that research, you can also reach me directly at bon@IWPR.org.
Thank you. And Rachel?
And I'm on Temple Law School in Philadelphia's website. I'm actually transitioning from being dean here at Temple to a law professor at the University of Texas in Austin. So I will join the law school there and work on a project that's related to reproductive health and the like. And so I'll soon be on that website, but happy to answer any emails. It's just my last name at temple.edu, same UT Texas at utexas.edu. Use the Temple one. I don't know the Austin one yet. But very happy to answer any follow-up questions about shield laws or the like.
Thank you both so much for joining us. And I will briefly pitch also the Roosevelt Institute as a place that people should go. Rachel, as I said at the top, is a fellow here at the Roosevelt Institute. We also have a series on our Substack, Fireside Stacks, that you can check out, where I interview economists like Kate and experts like Rachel on these issues. We're really glad to have everyone join us today. And thank you for joining all Roosevelt events, and stay tuned for more conversations like this. Thanks, everyone.
Thanks. Bye.